Yeah, good afternoon from here. I don't know whether we are audible from here, but your voice is not coming to us. Yes, please. Are we audible? We can't hear you.
To board, so sound important folks is very important. Is that me?
Yes.
Hello.
Okay.
Hello.
Yes,
on.
yes, okay now.
Okay, can you hear us now?
Yes,
Okay, wonderful.
loud
Assalamu
and
alaikum.
clear.
This is Manahil Toor from the Center for Chinese Legal Studies. I'm going to hand this over to Dr. Sikandar Shah, who's our director at the center and also an associate professor at the law school.
Good morning, Justice Bokhary. Glad to have you here, and we're very excited. And I'll start off with a brief introduction about you, and also we have some brilliant students of international law here. So please do bring international law to the discussion. What we plan to do is, my recommendation would be that you have an hour-long presentation or a discussion, and then we can have, well, the discussion can follow subsequently. The students are very interested in asking you a lot of questions. So maybe have it in an interactive way. If the students have a question in between, you feel free to raise your hand, and we will ask that. I mean, we'll bring the mic to you. Okay. So just quickly, it would be a pleasure to introduce you. Students and those who are joining online, it is my great pleasure to introduce today's session, which is part of the CCLS talk series. This series has been launched by the Center for Chinese Legal Studies to bring together distinguished voices from across the globe to share knowledge, spark dialogue, and deepen our understanding of law in both national and international contexts. At SASON and CCLS, our mission is to build academic and cultural bridges, fostering dialogue not between Pakistan and China, but also with other jurisdictions and perspectives that shape global governance, business, and law. Through initiatives such as language programs, academic collaborations, and partnerships like this talk series, we strive to create opportunities for students, scholars, and practitioners to engage with pressing issues of our time. Today's session is a special honor for us. We are privileged to honor and welcome Honorable Justice Kemal Shah Bokhary, one of the most respected voices in international law. Honorable Justice Kemal Shah Bokhary is a non-permanent judge of the Hong Kong's Court of Final Appeal and an honorary professor in the Faculty of Law at the University of Hong Kong. He was called to the English bar in 1970 by the Middle Temple, of which he was made an honorary bencher in 2001, and was admitted to the Hong Kong bar in 1971, and appointed Queen's Counsel in 1983. From 1971 to 89, he practiced in Hong Kong and before the Judicial Committee of the Privy Council in London, principally in commercial matters and public law. He was appointed to the High Court in 1989, then to the Court of Appeals in 1993, and ultimately to the Court of Final Appeal in 1997. During the 15 years, Honorable Justice Bokhary served as a permanent judge of the Court of Final Appeals. He participated in almost every constitutional case which came before the court and is widely respected for the deep sense of commitment and responsibility he brought to this to his role. Again, I would like to welcome him, and we are deeply honored. And I would hand over the virtual podium now to Justice Bokhary.
I esteem it an honor, a very great honor, to address you. And for this opportunity to do so, I thank our hosts. There are many persons who deserve to be mentioned by name among those in Pakistan who have ordained, commanded, inspired, and facilitated today's talk. But they know who they are, and you know who they are. In Hong Kong, we have had the assistance of the representative of the country in Hong Kong, the Consul General himself, and he has been ably assisted by his lieutenant, Mr. Hon'able, who has not been deterred by rain or tempest from making the necessary arrangements. My knowledge of Pakistan's legal system is limited. I must therefore rely on your indulgence. Doing so, I venture between Pakistan's legal system and Hong Kong's. Comparative law matters. What do we really know of our own jurisprudence if we only our own jurisprudence know? Mr. Justice Story called English common law the grand reservoir of all our jurisprudence. Each common law jurisdiction has developed its own common law. Take, for instance, the test on when exemplary damages are available. In Yuren, an Australian consolidated press, the High Court of Australia chose not to replace the Australian test with a new test devised by the House of Lords in Rooks and Barnard. The Privy Council respected the High Court of Australia's choice. Lord Watson was called the Privy Council judge par excellence. Why? For endeavoring to interpret the law according to the spirit of the jurisdiction from which the appeal came. The Privy Council never applied to any people any rule unsuitable to their habits and conditions, at least not knowingly. Of the many schools of Western jurisprudence, natural law comes closest to the Sharia. That is the view taken by Professor J.N.D. Anderson. It is the view I share. Consistent with it is Professor Majid Kaduri's point that in Islamic legal theory, the law preceded society. In the case of Miller and Taylor, Mr. Justice Aston said, the common law, now so called, is founded on the law of nature and reason. That statement was made in the presence of Lord Mansfield, and Lord Mansfield did not contradict it or even qualify it. Pakistan and Hong Kong share common law roots. The dimensions of those shared roots includes a constitutional one. I have in mind the opinion of the United States Supreme Court in the case of Smith and Alabama, delivered by Mr. Justice Matthews. He said, the interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of English common law and are to be read in light of its history. Pakistan's judicial strength comes from challenges bravely met. Your legal practitioners in private practice and in the departments, offices, and organizations all pursue the profession of the nation's founder. At the zenith of the four great schools of Islamic jurisprudence, the chair was more influential than the bench. Inspired by that example, Pakistan's legal academy will impart what Dr. Johnson called illumination of the mind. Who was, I once asked Chief Justice Bhagwati of India, the greatest judge from the subcontinent to serve on the Privy Council? Amir Ali, of course, he answered, looking surprised that the question was even thought necessary. The tributes to the Right Honorable Mr. Syed Amir Ali are many. They include a reference to his great learning made in the august tribunal, which he once adorned. The Judicial Committee of the Privy Council, whose jurisdiction once exceeded a quarter of the world, both by land area and by human population. Analysis without history is blind. So said James Fitzjames Stephen, with a lot of whose sayings I agree, even as with a lot of them I am unable to. With this one, for China trade purposes, Britain wanted a possession on China's southern coast. China ceded Hong Kong Island to Britain by the Treaty of Nanking, which was entered into in 1842 and ratified in 1843. In fact, Britain had acted on the agreement in principle under the so-called Convention of Chenpui, entered into occupation of Hong Kong Island in January of 1841. On a personal note, may I mention that 17 years after that, my great-grandfather on my mother's side, with origins in the Gulf states, was born in Hong Kong. We have been here for quite a while. Coming back to general history, in 1860, the colony of Hong Kong was expanded. That was done by the ceding to Britain under the Convention of Peking of Stonecutters Island over there, and the portion of Kowloon Peninsula over there, south of the aptly named Boundary Street. In 1898, the new territories further on there were leased. Now we moved from cession to leasing. Leased to Britain for 99 years under the second Convention of Peking. Upon entry into occupation of Hong Kong, Britain proclaimed as follows: pending Her Majesty's pleasure, Chinese inhabitants would be governed according to Chinese laws, customs, and usages, administered by village elders under a British magistrate's control. British subjects and foreigners were extended the protection of British law. In 1843, by an exercise of prerogative power, Hong Kong was given a legislature, then and now called the Legislative Council. The Supreme Court Ordinance of 1844 placed everybody in Hong Kong under the protection of English common law and equity. that was subject to such judge-made modifications as local circumstances may require. It also made room, some room, for ethnic Chinese domiciled in Hong Kong, for which purposes domicile was interpreted rather generously, to resort in personal and religious matters to the laws and customs of traditional China. Appropriately. After all, traditional China itself had accommodated several legal systems. Permit me to pause here to say this. Even as I, a Muslim, reference Islam with reverence, I remember the founders' equal inclusion within the nation of members of other faiths. From a small fishing, farming, and stone cutting community, Hong Kong evolved into an entrepot, then to a hive of tourism and light manufacturing, and finally into an international financial center, which it is today. We have our harbor and the Pearl River Delta, always so called, even though it's an estuary, for a hinterland. Otherwise, our only natural resource is our people of many faiths, ethnicities, and origins. Circumstances have instilled in us of necessity a strong work ethic and an abiding commitment to the rule of law. Similar characteristics exist, I have no doubt, in every Pakistani true to the precepts upon which the founder's life is emblematic and indeed talismanic. The British era ended on the 1st of July, 1997. On that day, China, acting under the Sino-British Joint Declaration of 1984, resumed the exercise of sovereignty over Hong Kong. That event, commonly called the handover, ushered in the one country, two systems principle. It is a principle which preserves our previous system for at least 50 years. In addition to treaty, such preservation is entrenched by our post-handover constitution, the Basic Law. Upon the handover, the Hong Kong Court of Final Appeal became our court of last resort. Pre-handover, Hong Kong's constitution consisted initially of the Hong Kong Letters Patent and the Hong Kong Royal Instructions. Being of imperial creation, these instruments were beyond the power of a colonial legislature to abrogate or amend. On the 8th of June, 1991, we received a third constitutional instrument, namely our Bill of Rights. This reproduces the International Covenant on Civil and Political Rights almost verbatim. Simultaneously with its coming into force, the Bill of Rights was entrenched by an amendment of our Letters Patent, the instrument to which our legislature owes its existence and its powers. This amendment prohibited our legislature from restricting rights and freedoms under the International Covenant on Civil and Political Rights as applied to Hong Kong. That means the Bill of Rights as the embodiment of the International Covenant's application to us in Hong Kong. In 1913, our judiciary said that enactments beyond our legislature's lawmaking power would be pronounced bad. But the lawmaking power conferred on our legislature by the Letters Patent was to make laws for peace, order, and good government. Britain always used those words to delineate the ambit of colonial lawmaking power. At the judicial apex of the British Empire, the Privy Council consistently held those words to confer the widest possible lawmaking power. Constitutional review, as I call Marbury and Madison judicial review, was therefore more theoretical than real here until the Bill of Rights. Since then, our judiciary has exercised constitutional review in earnest. Pre-handover under the Bill of Rights, now under the Basic Law and the Bill of Rights. As a national law, the Basic Law is beyond the power of the Legislative Council, being a regional legislature, to abrogate or amend. The Basic Law enumerates a wide range of civil, political, and socio-economic rights and freedoms, all of the kind with which Pakistan is familiar. It also entrenches the Bill of Rights by providing that the International Covenant, as applied to Hong Kong, in other words, the Bill of Rights, shall remain in force here. Judicial stewardship of an entrenched constitution is common to Pakistan's legal system and Hong Kong's. Pakistan's constitutional jurisprudence has many qualities, all of which I admire, and they include the quality that Professor C.L. Lim called a dislike of paying homage to principle when outcome risk being orphaned. I have observed and admired in the jurisprudence of the Supreme Court of Pakistan a commitment to producing not platitudes, but just results. If we talk the constitutional talk, we must walk the constitutional walk. 5 Court of Final Appeal decisions reveals the essence of our constitutional jurisprudence. Permit me to say a word about these. We treat striking down as a course of last resort, exercised only when legislation cannot be saved by remedial interpretation. In the case of official receiver and Chan, the legislation involved stipulated a period after which bankrupts are discharged from bankruptcy. But it also provided that if a bankrupt leaves Hong Kong without notifying his trustee in bankruptcy, the period ceases to run until he, having returned, so notifies his trustee in bankruptcy. Plain beyond remedial interpretation, that went further than necessary to protect creditors. We therefore struck it down for incompatibility with freedom to travel. Legislation savable by reading down or reading up will be so saved. On its face, the firearms legislation in the case of HKSAR against Lan Kwong Wai cast incompatibly with the presumption of innocence a persuasive burden on accused persons. We saved the legislation by reading it down to an evidential burden. In W, against the Registrar of Marriages, we held that W, having undergone gender reassignment, was entitled to marry in the reassigned capacity. There is a constitutional right to marry. Confining it to marrying in the pre-reassignment capacity would make a mockery of the reassignment. We read the words of gender in all our matrimonial legislation up to include reassigned gender. When striking down is unavoidable, we tailor it to preserve the statute as far as possible. In the case of Kuhn and the Insider Dealing Tribunal, the tribunal, acting under securities legislation, empowering to impose what amounted to a fine, fined an insider dealer. This fining power rendered the tribunal's proceedings criminal rather than civil. If the proceedings remain criminal, the finding of insider dealing could not stand. First, because it was reached on the civil rather than criminal standard of proof. Secondly, because it was reached partly on compelled evidence, admissible only in civil but not criminal proceedings. We rendered the tribunal's proceedings civil by striking down the fining power and setting aside the fine. That preserved the finding of insider dealing, and with it, the disqualification, disgorgement, and costs ordered by the tribunal. The striking down, you will notice, was of a provision unobjectionable in itself. In a criminal court, insider dealing is punishable by a fine and or even imprisonment. But as we understood the legislature's intention, the fining power was less important than the features of the tribunal scheme saved by striking down the fining power. Innovative, but less than, far less than, the Supreme Court of Pakistan was innovative in the celebrated case of Shelazia and Wapta. Normally, striking down simply rids the legal order of an unconstitutional encrustation. What if the arrangement struck down was an unconstitutional attempt to something worth doing constitutionally? Then we held in the case of Kuhn and the chief executive, the striking down order may, in cases of necessity, be suspended for a limited period to afford an opportunity to enact corrective legislation. The constitutional challenge in Kuhn's case was to covert surveillance conducted by law enforcement agencies under legislation as purportedly augmented by an executive order. Article 30 of the Basic Law protects freedom and privacy of communication, subject only to the relevant authority's power to inspect communications in accordance with legal procedures. Remember those words, legal procedures, to meet the needs of public security or of investigation into criminal offenses. The executive order merely provided a set of administrative directions. They did not amount to legal procedures within the meaning of Article 30 of Basic Law. The impugned legislation was declared unconstitutional insofar as it authorized access to or disclosure of the contents of any message, but to afford an opportunity for corrective legislation. The High Court granted and the Court of Appeal affirmed 6 months temporary validity. We, in the Court of Final Appeal, replaced it with 6 months suspension. The difference is this: temporary validity enables the executive temporarily to act under what was declared unconstitutional. It also provides a shield from legal liability for so acting. Suspension provides no shield. It merely enables the executive during the suspension period to act under what was declared unconstitutional. Temporary validity was accorded by the Federal Court of Pakistan in the case of Special Reference Number 1 of 1955, and by the Supreme Court of Canada following that decision in the Manitoba language rights case. The former, the Pakistani situation, involved a virtual legal vacuum, while the latter, the Canadian situation, involved a virtually blank statute book. Absent a shield from legal liability, such dire situations might leave chaos in their wake, even after corrective legislation. Ku's case, the case for us, called only for suspension. Necessity, as Lord Mansfield said, will not justify going further than necessity obliges. When you get to know me better, as I hope we will get to know each other better, you will know that I'm forever quoting Lord Mansfield. Justifiably, I hope. Access to the courts makes meaningful Magna Carta's promise not to deny justice. Such access being the avenue through which judicial remedies are sought, I call it an articular right. The Supreme Court of Pakistan said in Kemal Shah, an election commission, that the Constitution bars the creation of an authority whose actions are not subject to law. In NAACP against Bottom, the United States Supreme Court stressed litigation's role in the pursuit of causes. The United Kingdom Supreme Court said in the Queen, Unison, and the Lord Chancellor that access to the courts is inherent in the rule of law. Judicial independence prevails in many jurisdictions, including Pakistan and Hong Kong. The concept is not exclusively Western. From 18th century China, we have, for instance, Sun Shu Qi's case. The Board of Punishments, in effect the Supreme Court of traditional China, made their decision. They then presented their decision to the emperor for endorsement. He, the emperor, invited them, the court, to alter it. They responded by respectfully but unequivocally counseling fidelity to the law as the best thing for the empire. Whereupon the emperor endorsed the decision as presented without alteration. Due process, by that name or any other name, is enforced in many jurisdictions, including Pakistan and Hong Kong. In the case of Tianyong and University of Science and Technology, Beijing, the People's Court of Haidan District, Beijing, enforced due process. This case was issued eventually by the Supreme People's Court as a guiding case. Fully faithful to the letter and the spirit of the Constitution, our judiciary and yours each seeks to give constitutional decisions that accord with the highest ideals of the people at their best. So endeavoring, every court does, in Lord Eldon's phrase, what it can. Hong Kong believes in what Lord Shortcourse called the right of humble folk not to be pushed around. The Supreme Court of Pakistan vindicated that right when preventing the conversion of a public park into a commercially operated golf course. Our basic law promises democracy. The Supreme Court of Pakistan has declared the legitimacy of governance to be conditional upon general elections being held. And the Peshawar High Court, you must let me mention the High Court of my hometown, has stressed the duty of a caretaker government to create an atmosphere conducive to free and fair elections. Chief Justice Kiani famously spoke of the imaginative consciousness of the judicial mind. Hong Kong recognizes that the law's development often requires exercises of imaginative faculties. In this connection, I should proudly point, to Mr. Justice Jawad Hassan's imaginativeness in Muhammad Ahmad's Pansauter and the Federation of Pakistan. The case, which is admiringly dealt with in a book I co-authored with two of my grandsons, does great credit to the learned lawyer litigant who brought the case and to the learned judge who decided the case. It calls to mind Lord Shaw Dunfermline's famous reference to sound imagination, which he made in the case of Watson, Laidlaw and Company against Potts, Castles and Williams. Your constitution mandates improving the right to life, which includes healthcare. Our constitution mandates improving medical and health services. We in Hong Kong do not initiate cases of our own motion, but I have written admiringly of how Pakistan does. I, with your permission, acknowledge my deep indebtedness to Mrs. Justice Aisha Malik for her splendid book and what it has shown me of the decisions of the Supreme Court of Pakistan. Those who know law derived from the sacred are well qualified to deduce law from the secular. I now thank you for your patience. Let me not trespass further upon your time and leave you some time to ask me questions if you like. And I will do my best to answer them. So now in conclusion, my wife and I, the brightest future, and that we do in the name of our grandchildren. Now, if anybody wishes to ask me any questions,
Yeah, go ahead. Okay.
I will endeavor to do so, answering them. Hopefully, your questions be leading questions to suggest the answers.
Uh, Thank you so much, Justice Bokhary. I hope my voice is audible to you.
Very audible.
Okay. So, firstly, thank you so much for speaking to us. It was an insightful session. So, my question pertains to a lot of strands of law that you've touched upon. You've mentioned different characteristics of judiciary, different tenets that are very fundamental to judiciary, as you've mentioned, the independence that the judiciary has and the consequent rule of law that it establishes. So, being the students of international law, when I was thinking about all of these tenets of judiciary, how would you suggest us, being students of international law, to imagine the role of the international judicial bodies such as ICJ and its other organs, Permanent Court of Arbitration and ICC? Because all of those judicial organs, when it comes to those fundamental tenets that you've mentioned about judiciary, don't actually exist, or at least don't exist as you've mentioned to be existent in jurisdictions like Hong Kong, etc. So, how would you suggest us? Should we even consider them as judicial bodies, or should like they exist in this system in another capacity as opposed to the judiciaries of Pakistan and Hong Kong? Thank you so much.
I think you should approach them in the way that you would wish that they approach themselves. It is interesting that these concepts of which I speak are all rooted in natural law, written in the heart, teaching us what is to be done and what is to be fled. And because it's written in the heart, cannot be altered by changes of time and place. And natural law is the law of nations. De Vattel said so in his celebrated book, The Law of Nations, when he said that the law of nations is natural law as applied to the affairs of nations and sovereigns. Now, there are political undercurrents, and one has to cope with them at every level, international and municipal. It can't be helped. But let us lift up our hearts and do our best. And one day, you may preside in all these bodies and tribunals. Prepare them for the day when you do. Sometimes one is discouraged. But remember, two men look through the bars. One sees the mud and one the stars. So lift up your spirit. See if you can lift up theirs. Thank you.
Thank you so much.
Should
Should I?
Maybe I think he could. Earlier. Hello, sir. Can you hear me?
I can.
Perfect.
Oh.
So we were recently studying about arbitration, So we looked at how Hong Kong is now like a global hub for international arbitration, especially for international parties that are contracting with different Chinese entities and basically uh, for huge contracts as well. So what do you think, like what are the challenges that the Court of Appeal basically face in enforcing those foreign arbitral awards? And this title that your judiciary is pro arbitration judiciary. So what are the judicial principles that you guys are basically working on that gives you that title and actually lets you maintain that title as well?
Well, we believe in arbitral autonomy. The law has always struggled to find a balance. The extent to which the Hong Kong courts will intervene in an arbitral award is, I think, fairly circumscribed. But we haven't washed our hands of intervention. When it comes to the enforcement of arbitral awards, we, of course, examine all the technical requirements. And there's ultimately at the back of it a public policy ground on which enforcement can be refused. But again, that is exercised with circumspection. I have on and off been involved, man and boy, in arbitrations. I remember being involved in arbitration about a sandwich. I'll tell you about that on some other occasion. And I have to say that if you have an efficient judiciary, then the advantages of arbitration, if advantages there be, are, in my view, limited to confidentiality. Except in one instance where I think the advantage of arbitration extend beyond mere confidentiality. And I think in terms of bilateral investment treaty arbitrations, where it is a bit much to ask either investor or host country to submit to the other's jurisdiction. So we are forever learning, forever open to ideas. I think we have been proceeding in a way which is acceptable, not to everybody's satisfaction. That's not possible. So that's how I think we're going. If you ever visit Hong Kong, come and see me. We'll have a chat further about it.
Now, please go ahead.
Great session, Justice Bokhary. I have a question regarding international law and how states position themselves. Considering how international law has often reflected power dynamics and have been considered a polarized party, with China increasingly positioning itself as a global power, sometimes challenging US dominance, do you think international law will adapt to reflect a more multipolar world order, or will it remain largely shaped by Western powers, or what we say, larger states?
I think that the change that you envisage and for which you hope is precisely the change which I envisage and for which I hope. there's no doubt that before the World Court itself, the national interests are very strong. Otherwise, why would there be the possibility of appointing an ad hoc court judge if you don't have one on the court itself? I mean, the international case that I often cite is the Southwest Africa case, second phase, Ethiopia and South Africa, which is the 1966 volume of the International Court of Justice report. We'll forgive an old man if he forgets the page number, but I think it's 6. And that was a case which was decided by the casting vote of the president of the court. And I've always thought ill of that, although I was too polite to say it to the president's son when I met him on one occasion. But it is graced and saved by the dissent of Judge Tanaka, which has put the right considerations as the appropriate considerations. So I'm not without hope. I am quite optimistic. I hope young people are. I believe myself to think rather like young people do. For this reason, one might invoke Eastern philosophy, Zen. It said that when you embark on the study of Zen, a mountain seems to you only a mountain. As you progress towards enlightenment, you see that a mountain is many other things besides. And then when you achieve enlightenment, you will see that a mountain is only a mountain after all. And therefore, somebody at journey's end, like you, at the beginning of the journey, probably think alike. You have not gathered the clutter, and I have discarded it. So there is a journey. Let us embark upon it with good heart, but humility. I'm reluctant to say this in the presence of so many princesses of the law that might be listening, but heaven's gates are not so highly arched as princess palaces. They who enter there must go upon their knees. So that is how one makes the ultimate and most important journey. The lesser ones also the same, with confidence, but with humility, with an understanding of the difficulties that some people feel in coming along with our way of thinking. And let's see what will be done in your time after mine. Thank you.
Thank you, Justice Bokhary, for that very insightful session. I had my question relating to Pakistan and Hong Kong both coming from the Commonwealth, deriving from it. So in Pakistan, we have seen that due to a lot of political pressures, the independence of judiciary is compromised a lot of the times. How has, in a couple of instances, if you could mention, Hong Kong dealt with such of those pressures?
Well, you know, if judges were never under pressure, we wouldn't talk about judicial independence. Judicial independence is manifested in the resistance of pressure. You see that case from traditional China that I quoted. The emperor did ask them to make the change. And frankly, if you look at the change that he asked for, it was actually quite a humane change. But the change was coming from a non-judicial source, and therefore it was resisted. Now in Hong Kong, we have never been pressured to give a decision contrary to our conscience. There is the power of reinterpretation by the Standing Committee of the National People's Congress, and that was said in some quarters to affect judicial independence. In fact, it doesn't really affect judicial independence. It affects judicial autonomy, of course, no denying that. And as I once said, if the judges in Hong Kong were not independent-minded, it would not be necessary to have a power of reinterpretation. You just pick up the phone, tell us what to do, and we would do it. But that's not how it works here. So judicial independence is not something which we enjoy like natural sunshine. It is something which we acquire in the difficulty of circumstances. Perhaps the greatest exercise of judicial independence was by Chief Justice Cook. In the case of commendams, the king asked them not to give a decision until he had been consulted. They declined, and they wrote him a letter saying that they could not do that as judges. They gave their decision. He sent for them. He tore their letter up and threw it into their faces. All the judges, including the Chief Justice Cook, got down on their knees before the king. Because remember then that there was a belief in the divine right of kings. And therefore, if you were on the wrong side of the king, you put your soul as well as your body in jeopardy. And the king asked for their assurance that they would, on the next occasion, consult him. And all the other judges seemed to murmur in the affirmative. But Cook, who was on his knees, said to the king that when I'm in court, I will do what it is right for a judge to do. So when it comes to judicial independence, it is the challenges that makes the independence. And in the body of the talk which I gave, which I hope did not bore you too much, at least none of you seem to fall asleep, I did advert to some of these things. I said that the judicial strength in Pakistan comes from challenges bravely met.
All right. Do we have any other question? All right.
Yeah, thank you for the session. Yeah. So my question actually stems from how you replied to the earlier question. So if there is a conflict between Hong Kong interpretation in court and the interpretation of the standing committee, which is directly under review, how would you sort of reconcile that issue or conflict?
I'm afraid the recording didn't come very clearly. Could you repeat your question a bit louder? I didn't hear it very well.
Yeah, so my question is that if there is a conflict between the interpretation of the Hong Kong's court and then the court in sort of the standing committee in Beijing then has a different interpretation, how do you reconcile those different interpretations?
Now, the Constitution provides for this, that if there is a reinterpretation, that does not affect the decision that you've already given. So that decision, the case is disposed of as per your decision. But as far as the future is concerned, when it comes to the interpretation of the basic law, the interpretation has to be according to the Standing Committee's decision. Because, in fact, under the national system, the power of interpretation rests with the Standing Committee, which they have delegated to us to exercise independently. But if they exercise it themselves, then what they say about the effects of the Constitution is as they say it is. Of course, one follows the interpretation itself and not everything that might be said in the course of leading to the interpretation. So if this and that and the other is said, you don't have to follow that. But when they say this is what it means, and they say it unambiguously, then that is what the Constitution means. And that is how power has been allocated between the Hong Kong Special Administrative Region and the nation itself.
All right, do we have any other questions? Andres, please go ahead.
Am I audible, sir? Am I audible, sir?
Yes, you are. Very audible and visible. I see the girls looking at you.
I had a question regarding the one country, two systems model in Hong Kong. So I'm just going to state the question that I studied that Hong Kong operates under one country, two systems model. It means that its laws related to human rights are distinct from the laws of the metropolitan China. So I just had a question and I wanted to understand that how does this principle affect the sovereignty and legal autonomy of the mainland China, because you are entering international obligations that are sometimes distinct from your mainland. The question is.
Sorry, go ahead. We do not enter into international treaties ourselves. All the treaties to which we have applied to us were entered into in British times by Britain and now by China, which extends it to us. And all the great treaties on the rights of children, the most highly ratified treaty in the history of the world, and the rights relating to women and all these other things were entered into either by the British sovereign or then the Chinese sovereign and extended then to the British colony, now to the Chinese Special Administrative Region. So we don't enter into these things separately. And of course, if you look at the rights, the fundamental rights that we have in Hong Kong, they're not frowned upon in China because, first of all those rights are very much like the ones that are in the Basic Law, which is an instrument of national creation. And in addition to that, the Basic Law provides for the continuation of the international treaties that we have entered into and the labor treaties for them to be enforced by law. The position is stronger in relation to the International Covenant on Civil and Political Rights than the one on social, economic, and cultural rights, for the simple reason that pre-handover, the civil and political covenant was localized and domesticated by way of the Bill of Rights, whereas the one on social economic rights has not been. I have said, somewhat a voice in the wilderness, that the social, cultural, and economic rights one can also be of strong influence in our approach to all our decisions. So that's how it's done. But I don't see that there's any hostility to these rights in China, because, as I said, they enacted a wide range of these rights in the Basic Law and incorporated the International Covenant itself.
Do we have any other question? All right. So we have one question in the chat. Maya, if you could read that out, please.
Should Hong Kong Court of Final Appeal also initiate cases of its own motion like the Supreme Court of Counsel?
Sorry, could you repeat that, please? Again, the mic went a little bit funny. The Court of Final Appeal.
Yes, so we have a question from Bilal Halim in the chat. It says, should Hong Kong Court of Final Appeal also initiate cases of its own motion like the Supreme Court of Pakistan?
Oh, right. Well, I wouldn't mind if we did it, but there is a difficulty, which is this. There are some constitutional courts of which the United Kingdom Supreme Court, the United States Supreme Court, and ourselves are courts only of last resort. There are some constitutional courts which are courts of first and last resort, like the Bundesverfassungsgericht in Germany, the South African Constitutional Court. And then there are some courts which seem to be able to function both as a court of first resort and last resort. Like the Supreme Court of Pakistan, you can receive the constitutional petition yourselves, and therefore it's easier to initiate action. Whereas these cases come to us through the High Court, and then the Court of Appeal, and finally to us, with some limited ability to leapfrog over the Court of Appeal. So it becomes difficult. The ability to initiate a case very much depends on it coming straight to you once you've initiated it. And we can't do that. Perhaps I initiate cases by some of the talks I give, encouraging people to do this, that, and the other. But therein lies the difficulty. If you can think of a way that we can overcome that difficulty, send me an email about it and I'll see what we can do about it. But so far, I can't think. Shall I ask you some questions? You know, when school inspectors used to visit schools in Hong Kong, the students were all told that if the inspector asks a question, all of you put up your hands. Those who know the answer put up their right hands, and those who know the answer put up their left hands. Of course, it's quite dangerous if they all put up their left hands, but you will all know the answer anyway, so it doesn't matter. So what's next?
All right, we have our last question. Please go ahead.
Here.
So you talked about how both Pakistan and Hong Kong, they both are colonies and they both, you talked about them in a comparative way. So my question is that when you quoted official R versus Chan, I think case where the restriction on the travel was there was a ban on travel on bankrupt people and that was lifted by the court of Hong Kong. In Pakistan, we also recognize international law, but do you think that the colonial heritage still governs international law in the international sphere and also the domestic law in the colonies? Because over here we have certain restrictions to freedom of movement, and we see our legislature coming up with like parallel systems like the military courts, which then infringe on people's rights legally. And what I think is like this is just an example of how still like we are our minds are colonized and we still like are bound by those principles that the mighty people should rule over anyone they can rule over. Like the international in the international sphere, the big countries have more power. In Pakistan, the ruling elite and the military have their own power and they exercise it and they infringe people's basic freedom, fundamental rights.
Well, the first good thing is that you said what you said, because in a truly oppressive regime, you wouldn't be allowed to say it.
Yeah.
The second thing is this, that coming back to the Hong Kong case, the bankruptcy legislation didn't put any limitation on travel by saying you can't travel or stop you. What they said is if you go out of Hong Kong without telling your trustee in bankruptcy, then the period that's running towards your discharge from bankruptcy stops. So that was quite limited. It didn't stop you from going out, but they say, well, it's a price you have to pay. And we said, no, that's not a price they have to pay. Don't be silly. Go away. So that's what it was. I certainly hope that whatever rights are infringed in Pakistan, I hope none will be infringed. They won't infringe your freedom to travel to Hong Kong, so you and I can meet.
Yeah, sure.
All right.
Have you ever been to Hong Kong? Anybody here been to Hong Kong?
I don't think
Anybody
anyone.
here been to Hong Kong? No,
No, sir.
you should invite
Ah,
them.
we must do something about that. The Consul General is sitting opposite me. He's weeping that you people are not visiting Hong Kong. Stop crying. I'll persuade them to come.
Justice Bokhary, thank you so much for your brilliant and comprehensive interactive talk. I can't thank you enough, and we look forward to having you here at LUMS hopefully soon. We welcome you to come as well as collaborate with you, even if it's online in the coming months and years, both at the law school and through the center. I also want to thank the Counsel General for facilitating and arranging this talk, and we look forward to collaborating with him.
Better bring him over here. Better bring him over here.
Thank you very much.
Thank you so much. And I myself have been associated with the Foreign Office, so it will be a true pleasure. And last but not least, I want to thank Justice Jawad Hassan, who helped me arrange this talk with you. And he's a big source of inspiration and mentorship for us here as well. And we all look forward to collaborating as a group in the coming time. Thank you so much, and hopefully see you here soon.
Thank you very much. Most grateful to you and grateful to many as well, if I may call this so.
Thank you.
Thank you.
Thank you, Ji. Bye-bye.